Okay, so this is our fourth live session. We've got 2 more sessions left, and we're dealing this week with trademark, and particularly the use of trademarks in domain names. Okay, so I'm going to start with course updates. The first thing is that the discussion board is going to open after class. We're going to discuss the question in a moment. We're discussing it at the end of this this PowerPoint. The other thing is the office memorandum is going to be posted tomorrow afternoon, and I'll post an announcement with it up. And I'm going to change the due date to August 13th at 11 p.m., so that will give you more time to work on it. The other thing, unfortunately, is I'm not going to be reachable from August 6th and through the 12th. So you can contact me by text on my cell phone, which is 954-612-8807, and I probably won't be online during that time because where I'm going has a very iffy internet connection. So try to review the office memorandum before August 5th to ask me questions. So you know, it's the summer and this is my only week off, so please bear with me on that. And that's why I'm making it due a little bit later, because I'm not going to have time to grade it then, so I figured I'll give you more time to work on it so that you don't feel rushed for time. Okay, so I'm going to start talking about what the trademark issues are for internet content and domain names. Okay, so the first thing that we have here, just a couple of things, the trademark names, and then the registered trademark. So a couple of things we're going to discuss. There's a difference between a trademark that's recognized, which is this first symbol, the TM, and a registered trademark. And then these other things are basically the ends of domain names. I'm not going to talk about domain name assignment. There's a lot of things about that you can look up later. I'm just going to really talk about the trademark component of it in this discussion. The first thing is why use a trademark. And so the first thing, a trademark is a legal signal helping me find a product. So if I want to find a product and I know what the trademark looks like, it's easy for me to find that product either online or in a store. And also the mark is a promise of quality. Also, the mark protects the brand value against competitors. So basically, it keeps you from having to deal with competitors who might try to use the same mark. And the book Grimmel talks a little bit about Coca-Cola. Coca-Cola is like one of the most recognized trademarks in the world, and it's one of them that has been infringed a lot by other products. So when you think of a trademark, you can think of a number of them. Anybody else know of any trademarks that they've seen or used or they're kind of popular? You guys have seen them all over the place. Come on, let's throw out some trademarks. You can type them. Nike, yeah, the swoosh. McDonald's, big one. Any others? Some of you carry a phone that has a big trademark on it. General Mills, Apple, yeah, Apple. Yeah, all of those. So basically, you know, trademarks, you know them when you see them because immediately you identify them with some sort of product. And that's what happens with trademark infringement. Someone's trying to get into some of that goodwill from the product. So we'll talk a little bit more about that in 1 second. So what is a trademark? So basically, a trademark is a word, phrase, or other symbol that identifies to consumers the source of a product or service. And this comes from your book, the Grimmel Internet Law Cases and Problems. Does everybody have this book? It's online at Semaphore Press. It's on the syllabus, and you don't have to pay for it, but there's honor system for paying for it. So I hope that you guys did get a hold of it. I wasn't going to post it on the website because they're asking for a minimum like $8 to print it, but you don't have to do that if you don't want to. So just let me know. Hopefully you can get a hold of it because it's part of your reading for this week. Okay, so basically trademark acquisition, there's really two main ways to get a trademark, and I'm not going to again go through all of the trademarking policies. There's courses that are taught in this. The first one is registration with the United States Patent and Trademark Office. Basically, there's a procedure for it, how to establish it and all that. Not going through it. If you want to look it up, it's online, but that's not part of this course. The other way that is also done, and this is probably in a lot of ways the more common way especially for smaller businesses, is prior use in the market. Someone uses it in the market, and that could be limited to a geographical area. For example, you might have a trademark, on the East Coast, but not on the West Coast. And it's not dependent on novelty, invention, or discovery. So it doesn't matter if you're the person who discovered it or came up with it. What matters is if you use it and how you use it in commerce. So that's pretty much how you get the trademark. So I'm going to talk a little bit about the domain name system and this group called ICANN, ICANN. And I'm going to give a little bit of a history, and it's actually from their webpage. I have the link down below that talks about how this started. And the reason why I want to talk about it, because it really grew out of the United States initiative from that the global framework paper that we talked about, and later developed into an international organization. So here we go. So in 1983, basically the Internet Net Assigned Numbers Authority was established under a contract with the Defense Advanced Research Project Agency, DARPA, a U.S. Department of Defense agency, and the DSN was actually invented about 2 years later in 1985. And then in 1988, the National Telecommunications Information Administration created a proposal to improve the technical management of Internet names and addresses. And this has a link to that in case you want to look it up. It's a really boring document. I'm not recommending it. Also known as the Green Paper. And it presented a plan for transferring the management of the DSN from the U.S. government to a new nonprofit corporation based in the U.S. but globally recognized. And then in response to that, there were comments on the Green Paper. The U.S. Department of Commerce released the White Paper, officially titled Management Internet Names and Addresses, and the White Paper continued to call for a private nonprofit corporation to administer Internet names and numbers. It outlined 4 principles to which the new entity should be committed, which is stability of the DSN, competition, private sector, bottom-up coordination, and diverse and global representation. So this is kind of the birth of the domain name system. The second part, then the International Forum on the White Paper was formed and was held over 4 meetings, and basically the upshot is this: on October 1988, John Postel sent, and he's the guy who first formed the IANA, sent the Department of Commerce draft bylaws for a new corporation responsible for DSN management, and the draft was then released for public comment and is the basis for ICANN's original bylaws. And then the Internet Corporation for Assigned Names and Numbers, that's what ICANN is, was incorporated in California as a nonprofit public benefit corporation. And then finally, on November 25th, 1998, the U.S. ICANN and the U.S. Department, U.S. Commerce Department entered into a memorandum of understanding, and ICANN's roles focusing on managing technical DSN functions, the numbering of Internet addresses, and the coordination of port assignments and assisting in the management stability of Internet's unique identifiers. And the MOU required regular reporting to the U.S. Department of Commerce. So that's kind of how this started in terms of these two different systems. So as a result of this, we're going to come back to this a little bit later. There's two different places for looking for what happens with confusing trademark names in the Internet. One is U.S. law. The second is policy that is formed by ICANN. So that's really what we're getting into a little bit here. That's why I described these two things, not because I thought it was especially interesting. It is interesting, but it really gives you a sense of how these things evolve. The U.S. was the lead nation in creating this, but it is an international organization that has a relationship with the U.S. government, but it's not run by the U.S. government. Okay, so for trademark law, we need to look at something called the Lanham Act, which was created in 1946, and that's and basically it deals with the protection of trademarks. And the first thing is that it prevents the use of similar or identical marks in a way that confuses the public about the actual source of goods and services. So the Lanham Act in this way is a consumer protection statute. It's meant to protect consumers from being fooled by the use of something that looks close to somebody else's trade name, and the protection of the goodwills that companies have built up in their trademarks. So here's an interesting question. Has anyone gotten something that looks a lot like a good from a particular company but is not really from that company? For example, I like Coach purses. And sometimes, I'll go to someplace traveling down in the Caribbean and they'll have a lot of Coach purses for sale on the street, except for they're not really Coach purses. That's what's called a knockoff. And basically someone's using that trademark to sell the item. Anybody else ever find or buy a knockoff item? This was also really popular in New York in terms of street sales. Anybody else buy a knockoff item? Anybody? No? Fake items? No fakes Rolexes, or that was also popular? No one has gone and bought a fake item that looks like a real one. Okay, you got a fake shade. Okay. A Fendi. Okay, yeah. See, there you go. Yep, when you visit Thailand, especially when you go overseas. Golf clubs. Yep, there you go. They're all over the place. These knockoff things are all over the place. A Louis Vuitton, that's another big one, yes. So you'll find them all over the place, but they violate U.S. trademark law, which is why they tend to operate in these, like flea markets, places that are kind of, not quite where they're supposed to be. There's a case which I came across when I was looking at this, a Tiffany case dealing with eBay, where someone was selling fake Tiffany stuff on eBay and they're trying to sue eBay, not the seller. And so basically trying to get eBay to foot the cost of it. So these issues are really present, and they're not just present with products, they're also present with the main names. And this is where this issue comes up. So with the Lanham Act, and this source, by the way, it's one of your readings, this e-commerce and internet law. So you can look at more into this when you look at the readings. Okay, so for trademark infringement, in order to prevail, you've got to show a couple of things. First of all, that you own the protectable mark. And that goes back to the two ways that you have to show that you have a mark, either by prior use or by registration. Those are the two ways that you show that it's my mark, I registered it, or I've been using it. The second one, and this is probably the most, after that threshold, it's your mark, the likelihood of confusion, mistake, or deception with respect to the origin, affiliation, or sponsorship of a product or service that is used by a defendant. So basically, you are confusing the consumer. It's the consumer that we're looking at, whether the consumer is going to be confused about who made the product. So That's what we're looking at in trademark infringement. And again, it's about consumer protection. So they don't think I'm buying, you know, a Louis Vuitton, real one from France, and getting some fake one that's made in some other part of the world. So that's what we're talking about here. And obviously, those companies that are being imitated have made a quality product that somebody else wants to somehow use that goodwill and the quality of that product to sell their own, even though it's not the same product. So this is where it gets a little bit boring, but we'll come back and make it a little bit less boring. There's 8 basic criteria for in traditional trademark cases for confusion based on the use of a trademark. The first criteria is the strength of the plaintiff's trademark. So like I mentioned the Coca-Cola one, we've mentioned Louis Vuitton, we've mentioned Apple, we've mentioned a whole bunch. The stronger that it is, the more recognizable that it is. That's the first thing. So if somebody has a trademark that someone instantly sees or sees it can be the way it looks, like the Coke bottle, the shape of the Coke bottle, for example, has been deemed to be a part of the trademark as well. So if you create a beverage in that same shape, that could create confusion. So basically that's the first thing. The second one, the proximity of the goods and services. Are they the same type of goods? If you're selling a Coke and it's a beverage, if you're selling a Coach purse, that's one thing. But if you're selling a Coach chair, that's different than the purse. So those are different types of goods and services. And it could also be the geographic proximity as well. So are you selling it in the same area where the trademark is established? The degree of similarity between the competing marks or designations. So does it look a lot like it or not a lot like it? Are they, and basically it's the sight test. You look at one, you look at the other and say, gee, do I have to check between the two, those games that you have, so what's different here to see the differences between them? Or is it clear that they're different? And sometimes people do things like try to change the color, part of the shape, but they're still trying to preserve a little bit of the trademark because they want to create a little bit of confusion. So there's been a lot of things with respect to that as well. What's the next one? Hold on. The evidence of actual confusion. So basically finding out whether or not consumers were actually confused, whether or not someone went to go for one thing thinking it was another thing, or purchase something thinking it was the other thing, meaning that somehow they have mixed up the trademarks. I'm going to go back. The marketing channels used, how was it marketed? Was it marketed in the same place that the original good is marketed or in different places? And that's another big thing. Obviously, if you're buying a Louis Vuitton on a street corner, if you're confused, you're not really smart because it's not going to be a real thing. If you're buying a Rolex on a street corner, please, if you expect it to be a real Rolex, you are a bit gullible, let's just say that. The second one, the types of goods, classes of prospective purchasers, including quality and the degree of care likely to be exercised by the purchaser, alternately characterizes the sophistication of purchasers. So is this something that's highly specialized that the purchaser is going to be able to immediately spot the fake or not spot the fake based on quality, or are they likely to be confused because they're ordinary purchasers and they don't know the difference? Again, going back to the purses, if you know what the expensive purse looks like, you're not going to be confused by the cheap purse. I mean, you're going to look at it and think, well, this is good enough for me to carry around, but you're not going to be confused and think it's the real thing. And that's kind of what we're looking at here. And again, but if that purse is sold in the store versus on the street corner, then you could have the likelihood of confusion. So that's what they're looking at, all the factors. The defendant's intent in selecting its own mark. So why did the defendant select the mark that they selected? Did they select it because they knew it was going to be confusing, or did they select it because, oh, we like the mark? chances are they were selecting it in the confusion cases. They're selecting it so that you will confuse. If it's more innocent that we came up with a mark and weren't aware of it or didn't intend to confuse it and somehow it did, that's a different thing. But if you knew about the other mark and you were trying to make them look similar, that's another thing the court's going to look at, whether or not that was your intent. And finally, the likelihood of the expansion of the product lines, alternatively phrased, the likelihood the plaintiff will bridge the gap between its market and the business of the defendant. So I was talking about, Coach purses. Well, what about Coach watches? What about Coach eyeglasses? Those are things that Coach now markets, but if I came out and started doing that before Coach started marketing it, would that be an infringement? So those are the types of things that they look at. All of them are kind of like accessories, Coach, watches, glasses, and purses, so that might show the likelihood of confusion. But, if I created a Coach mug, I don't know that that's necessarily going to create confusion unless I try to make it look like a purse. I don't know. Anyway, that's what they're looking for. So are there any questions about these likelihood of confusion? Anyone know of any cases where, apart from what I've just mentioned, or heard of cases where someone's tried to pass off one mark for another mark? If you have it, there's going to be some in your reading that you can take a look at. And particularly there's a case by Hasbro versus ASUS computers, and we're going to talk about that. You're going to read that, and that's what your discussion question is going to be on. Okay, quiet. Everyone's quiet, because I think you're hoping that I'll go. Michael Jordan's jumping. Yeah, Michael Jordan stuff is really. There's been so many knockoffs on his products, big time. Yeah, he's been one of those that's been knocked off a lot. All right, and so the next thing too, this is the source of this is also one of your readings. It's going to be e-commerce and law, but this actually comes from a California or Ninth Circuit case. These are from the Ninth Circuit, from a case called Sleek Craft, which is going to be mentioned a lot in the case that you're dealing with. So this criteria is mentioned a lot, and they say it's coming from the Ninth Circuit, which is the circuit that came up with it. It's the most comprehensive list. All right, so for the internet, the confusion cases are a little bit different. Some factors are more important than others, so the courts are more flexible. And some of those 8 factors are not going to apply to the internet. So they created a 3-factor test. Sometimes they call that test the Trinity test, sometimes because it's 3 factors. So the first thing is the similarity of the marks. And because remember, the internet is very visual, and we tend to see things more visually on the internet. There's writing, but the visual part of it's important. The relatedness of the goods and services. So are these goods and services related? Are they similar? And finally, the party's simultaneous use of the web as a marketing channel. So are the plaintiff who is claiming infringement and the defendant who is doing the infringement both using the internet to market the product? Some products are not necessarily marketed on the internet, or sometimes they're mainly done by in-person sales. So it really depends. So these are the main 3 factors that they look at. Now, not to say that they don't look at any of the other factors to the extent that they could apply, but these are the key factors that they look at for internet. So the next thing is cyber squatting, and cyber squatting is something that's done quite commonly, and it's basically the incorporation of a trademark in a domain name motivated by, first of all, bad faith, and the second one is the intent to profit from the goodwill of the trademark. So has anyone ever run into what's called cyber squatting? Has anyone ever run across that, seeing somebody else's name used in a particular internet address? You type in something and you get a search and you click on the link and you get something else that's weird. Anybody else? Anyone experience that? You're sitting back and saying, no, I haven't experienced anything. My life is empty. Okay. You guys, anyone? Your life is not empty. Come on. No. Okay, so um, here's a good one. Type in Google, but spell it Goggle on your computer. See what happens. Spell it goggle. Did anything happen? Your computer didn't explode, I hope. It autocorrects. Okay. So that's the interesting thing, because before it used to, it went to Google. Okay. So before it used to go to strange websites. So now this is a cool thing about technology. It's correcting the wrong names, which is interesting, because it says, do you mean this? Do you mean that? I'm trying to think of another one. No, I'm not going to think of any more. But sometimes when you do type in things, it'll lead you off site. Okay, so what does cyber squatting require? Cyber squatting is basically, this is becoming less and less, it's happening less and less. This used to happen a lot more. It's happening less and less because it's been regulated and people are watching out for it a lot more. In the case that I was talking about between eBay and Tiffany, one of the things that Tiffany used to do is periodically would look and check to see if anyone was using its trademark, but it didn't do it on a regular basis. It kind of did it maybe like once, maybe twice a week, which wasn't always enough time, enough to catch all the people selling the Tiffany products on other sites. So anyway, so basically cyber squatting requires you to adopt a trademark verbatim, usually to take the name of the trademark that you're trying to take. One of the ones that there was a big case about was Julia Roberts, someone taking her name. Adopt a confusingly similar variation. So just taking most of the name but changing a letter or two, so that somebody who maybe is looking for one thing will stumble across the other one by mistake. And that includes typo squatting, which is what I was trying to get you to do, but it's becoming less and less popular now because the search engines start asking you, do you mean this? And that's basically typo squatting is when a domain name incorporates common misspellings of a popular trademark. So it puts something in that is like a common misspelling, and usually a lot of times the misspellings are due to someone doesn't know how to spell it correctly and it's phonetically different, or because of proximity of keys on the keyboard, they figure out what the common typos are. So that's typo squatting. Again, it's becoming less and less popular because of the autocorrection function. Okay, so the next thing is the Anti-Cyber Squatting Consumer Protection Act of 1997. And this basically determines the bad faith use of a trademark and domain name by looking at about 9 different factors. And this is actually in the Grimmel book. It's on page 400. And it goes for a couple of pages, but it's part of U.S. trademark law, and it lists all the factors. It's Section 15 U.S.C. 1125 or Section 43 of the Lanham Act. So this is part of the Lanham Act, the thing that we talked about earlier, dealing with trademark law. And I'm just going to read you. The section is called Cyber Piracy Prevention, and it says a person shall be liable in civil action by the owner of a mark, including a personal name which is protected as a mark under this section, if without regard to the goods or services, that person, 1, has a bad faith intent to profit from the mark, including a personal name which is protected as a mark under this section, and 2, registers, traffics in, or uses a domain name that is confusingly similar to a registered trademark. And that's basically what we're talking about here. It can be a trademark and it can also be a personal name. So if I were really an important person, you know, and Jane Cross was a big name, and someone started using that name, that could possibly be a trademark violation. But right now, not so much because I'm just not that famous. And under that, is the 9-factor test. And I'm not going to go through all the factors because you can take a look at them on pages 400 to 401. But so it says it's basically in determining whether a person has a bad faith intent. A court may consider factors such as but not limited to. So when it says such as but not limited to, it means the court can look at other things as well. But these 9 are kind of the basic factors that a court's going to begin to look at. And it basically says things like trademark or any other intellectual property rights of the person in the domain name, the person's prior use of the domain name, that's one thing, the person's bona fide non-commercial or fair use of the trademark, and things like that. But then there's also what's called a safe harbor provision, and that says provides a safe harbor provision based on reasonable belief that the use of the domain name was fair or lawful. And that basically says, the section reads, bad faith intent described in subparagraph A shall not be found in any case when the court in which the court determines that the person believed and had reasonable grounds to believe that the use of the domain name was a fair use or otherwise lawful. So there's this big loophole which basically says that, you know, bad faith is going to be saved by an instance in which a person's not trying to operate on bad faith, when they think that they have a lawful or there's a fair use of the name. That could be in a situation, for example, when it's your own name. You know, if your name is also, you know, Michael Jordan or Julia Roberts, and you're incorporating that into something, and you're not trying to create confusion because it's your own name, that can also be a reason to use that name. So that again is on pages 400 to 401 of the Grimmel book. So that's one of the reasons why, this is from 1999, so we're a good 18 years later, that's why we have less instances of this cyber squatting and typo squatting, and also given the way that technology works, that the search engines can now correct it. And we know that there's competing search engines, so if you use a Google search engine or Yahoo, or who else am I forgetting? There's others, Bing, or if you use any of those search engines, Mozilla, thank you, Fox, Mozilla, that's another one, they'll give you different results, but all of them have things that will correct what you're searching for. So I think that's another interesting thing that has happened with internet searches. So the final thing I'm going to talk about is the Uniform Domain Name Dispute Resolution Policy. It's also called UDRP. And this comes back to the ICANN, that nonprofit organization that is in the United States but international. And so basically, if you register using them, if you get an internet address using that service, you have to follow their resolution policy to resolve domain name disputes. So under the U.S. policy, you're in U.S. federal court dealing with trademark. With this one, you're dealing with their internal provisions. So the first thing, disputes that allegedly arise from abusive registration of name can be expedited. So if someone's abusing your name, you can speed up the policy for using that. And to use the policy, a trademark owner should either file a court complaint, so you can use the U.S. Services, or in the case of a abusive registration, submit a complaint, and that's to ICANN. And so basically that's to get that, because we know that a court case can take a long time, but if it's an abusive one and you want to get it down really quickly, that's when you use that different system. And basically on pages 416 to 418 of the GRIML text you'll find a copy of that dispute resolution policy, which basically talks about the types of dispute, evidence of registration, selection of a provider. And it also talks about remedies. It talks about the availability of court proceedings, and also talks about the abusive use, the abusive registration. So that again is in the GRIML text, so you can take a look at that if you want a copy of that particular policy. But I'm also going to be giving you one of the readings talks about what's the differences between the two and why use one versus the other. It's written by an attorney, and I decided at the last minute that I wanted to put that in the reading. So I'm going to be putting the readings link I'm going to be opening that up after this chat session. After I put everything up, it's going to be all up at once, and you can read about this stuff. Okay, so the discussion board question. Before I start with that, any questions about what I just went through? This is not too long. I'm trying to keep it short. No okay, no questions. Yay. Quiet. All right, so the discussion board questions are going to come from the GRIML text, which is why I wanted to make sure that all of you guys got it. So what I want you to do is read the Hasbro versus ASU Computer International. It's on pages 378 to 387 of the GRIML Internet Cases, Law, and Problems. You got to read it there because you can't really find this case anyplace else. I've looked a couple of places for it, and you actually can find it online, but I want you to look at this. And I'm going to also post the question separately online. Does everyone have a copy of that before I go on? Is there anyone that doesn't have a copy of it? Okay, everyone's got it. Good. Yay. All right. So it's pretty simple. All right. So what I want you to do is I want you to answer the 3 questions on page 387, and that's going to be your discussion board question. I was looking at it and I thought, oh, let me add something really interesting. But this is it's an interesting, it's a really great case that deals with trademark confusion. And basically it has to do with Hasbro is the plaintiff. It has to do with the Transformers trademark. And it talks about what the court's discussion was, and basically it asks really three basic questions. And I'll read the questions right now. First one is, what was Hasbro selling using the name Transformers, and was what was ACES selling? How many of the sleek craft factors do these facts affect? So the sleek craft factors are those factors I listed before for the likelihood of trademark confusion. It's also in the case as well, so you'll see them really clearly. Is the court's discussion of how consumers use search engines persuasive? So the court discusses that. Suppose Hasbro wants to show that the Transformers mark has strong secondary meaning with consumers by introducing into evidence the first 10 pages of Google results in a search for Transformers, the vast majority of which refer to toys, cartoons, and movies. Should it be allowed to do so, basically? And if Hasbro's toys and Asus computers had both been Fuzzy-Wups instead of Transformers, would the results have been the same? So they're coming up with a random name, by the way. So that's all that they're doing there. So I'm going to be posting that problem shortly. But if you want to get a jump on it, go ahead and read that case and read the 3 questions afterwards. So the actual other readings are not really that long. but they're in there so you can become familiarized with the points that the case is talking about, and also with all of the things that I just mentioned. The readings that I'm posting are basically building on the concepts that I've introduced in this discussion. But the actual discussion deals with that particular case, and it's it's kind of a dense reading. So what I would do is I would read through it quickly, look at the questions, and then go back and read it through in light of the questions, or start with the questions, read it through quickly, go back to the questions, and read it through a little bit more in detail. But really, the case is pretty straightforward, so it shouldn't be that hard to understand. If you have problems with it, let me know. I say that it's straightforward, but I'm a lawyer, so sometimes I lose perspective on how difficult these things are to read. So please let me know if there's any difficulty with reading them. Oh yeah, is it in the syllabus? Yes, it's in the syllabus. It's definitely in the syllabus. The link is in the syllabus and you found it. Thank you, Denise. All right, it's in the syllabus. It's all there. So anyway, that's basically it for this week. As I said, I'm going to be doing the office memorandum. It's going to be there. It's going to be posted tomorrow afternoon. And our next chat session is going to be August 14th. And as I said, I'm going to be a bit incommunicado. So if something comes up and you need to get a hold of me, the best way to do it will be to text me, and I'll try to get back to you as soon as possible. Most of the day I'm going to be busy, so you'll probably hear from me when I have breaks. I'm going to be at a camp of sorts. I do Tai Chi, and I'm a Tai Chi instructor, so I'm going to Tai Chi camp. So if you want to know what's happening there. And that's the only time that I could go. So hopefully you guys will understand, and if you need to get a hold of me, you can send me a text, and I'll do my best to get back to you. Are there any questions? All right, so I just want to say you guys are doing really good on the discussion board. Please keep it up. Please make sure you try to get them in on time and respond to each other. I've enjoyed reading your posts, and I'm enjoying the fact that you're learning so much from the course. And I will make sure that I post the office memorandum tomorrow. If you have any questions, please take a look at it before I leave so that I can answer them in a timely fashion. Otherwise, it could take some time. All right. Thank you all, and you guys take care.